The Injuries Board is a state-created entity tasked with dealing with claims such as road traffic, public liability, personal injury claims. An application for assessment must be presented to the Injuries Board via post or applied for online to the www.piab.ie. The application must be submitted within time with the correct details, respondents' names / legal titles of the alleged wrongdoers on the form. A medical report obtained from the person's doctor must be provided with the application. Section 8 of the Civil Liability Act 2004 requires notification to the wrongdoer of the nature of the wrong which must be made. An application administrative fee applies to submit the application, which is €45 if the application is made online, or €90 if the application is submitted by post. Once the application is submitted to PIAB, they will proceed to register the claim. The Injuries Board then proceeds to notify the wrongdoer of the claim and ask them if they consent to the Injuries Board assessing the claim, whom then have 90 days to accept or reject the Injuries Board assessing the claim. They can furnish or refuse consent. If the respondent agrees to the Injuries Board assessing the claim, the Injuries Board will then do so and proceed to assess the claim. If the respondent disagrees with the Injuries Board assessing the claim, then the Injuries Board cannot engage with the matter and make what is termed an assessment of the claim. The injuries parties' avenue of recourse then is to proceed to court if they wish to do so. The Injuries Board have a legal discretion not to make a claim assessment under a number of headings, which includes if the claim is complex or if the respondent has noted to the Injuries Board they will not accept an Injuries Board assessment. For example, the Injuries Board, if assessing the claim, will likely arrange for the injured party to attend for an appointment with a doctor engaged by the Injuries Board. The Injuries Board will then have the injured party's own doctor's report and a medical report from a doctor engaged by them to assess the matter. Depending on the injury, there may be more than one report required by the Injuries Board. Some cases can have multiple reports within the Injuries Board process. The injured party will be furnished with a document for completion which deals with their monetary loss, which could be loss of earnings or medical expenses, etc. The Injuries Board furnish a notice of assessment to the injured party and respondent with the details of compensation for the pain and suffering and out-of-pocket expenses. The injured party has 28 days to accept or reject this. The respondent party has 21 days to accept or reject this. If both parties agree to accept the sum specified in the assessment, then an order to pay is made and the matter is concluded. If the person seeks legal assistance to deal with their application, a solicitor may not calculate fees or other charges as a percentage or proportion of any award or settlement.